Sure.
Good evening, everyone. I, on behalf of Legal Expatriate, welcome you all on the sixth day of our online 7-day online course on art of drafting deeds, agreements, and contracts. Due to unforeseen medical emergency, our scheduled speaker, Advocate Farhat Farsi, is unable to join us today. However, we have privilege of welcoming Advocate S. Thulasiram sir again on this platform, who will share the valuable insights in today's session. Thank you so much, sir, for taking out your precious time for us. We heartily welcome you again on Legal Expatriate. Now, without further ado, I request you to take over the charge and enlighten everyone with your expertise. Before handing over the session to our speaker, I also request all the participants to kindly keep their camera and mic off so that it would not create any hindrance during the ongoing session. Over to you, sir.
Thank you. Can you all see my screen?
Yes, sir. Yes, sir.
Okay. Uh, a very good evening to one and all. Thank you for a kind introduction. And as usual, very nice to be again on the Legal Expatriate meeting you all. And today's topics would be the these 9 to 14, and the 15th would be the case laws bonus for this session. Today, as I always tell, please have the mindset of learning something which is going to be useful on the practical front. uh, because we have all the books. I showed you Contracts Act 1872, Transfer of Property 1872, and Specific Relief Act 1963. And I also showed the Partnership Act. So all these things are there, and those are the inputs to Indian Contract Act 1872. Whenever somebody asks you anything, kindly develop is a problem or a deed. Okay. Yes, the PDF would be shared with you with all the performers to the legal expatriate, and in turn, it will be shared with you right after this session. So apart from that, kindly note your questions and don't ping me in between so that I will not be distracted so that it will impact the whole audience, targeted audience. So without any gap going into it, so today, like last 2 days, 3 days, we have learned what is a contract, and the contract are of two types. One is express contract, which is written in paper, and or the words through words spoken. Next is implied contract. Implied contract is contract which is formed based on the gestures, based on the behavior of two or more parties. Two or more parties. And the moment you step out, you are getting into a contract. The moment you get into cab, Uber, you are getting into a contract. The moment you are going into theater, you are getting into contract. The moment you are getting into court, you are getting into contract. The moment you are into, uh, for that matter, anything, you are into contract. For that matter, you are by birth, you are into a contract, and that contract is Indian Constitution 1949. So Indian Constitution is a four-part constitution. You all know that Indian Constitution. One has to read it, and it came into the force 1949. And this is a contract between four people. One is the politicians, which are legislations, union legislations and state legislations, so that is Parliament and Assembly. And next is the executives, who are IAS, IPS, MRO, VRO, revenue inspectors, police department. All of these are the executives. And the third one is judiciary. Judiciary means all the courts. And fourth is the public, normal public. The Indian Constitution is a contract which is connecting all those four people. So you read Constitution, you are going to read about the polity, legislators and parliamentarians, and you are going to read the executives, you are going to read among the people, and you are going to read the judiciary. So all these people, and it connects all of them. So if you have a problem, you can file a case in the judiciary, because the Indian Constitution enables Article 32 in case of Supreme Court, and Article 226 in case of High Court, and Article 227 in case of review. So suppose you have a problem with IAS officer, you file a case in judiciary. You have a problem with MRO, you go to IAS officer. So you have a problem with the election of a politician, you go to judiciary. So these are all like four part, right, agreement. So what I want is, as I told last time, try to capture the crux of Indian Contract Act first. And once you know the procedural law of Indian Contract Act, then writing it, reducing it, boiling down to a deed is very easy. Without delay, we are moving on to the the said items by legal expatriate. I will go through them. So okay, so you all can see this. I'm starting the session. You all can see my screen.
Yes, sir.
Oh, perfect. So whenever you're writing, these are the three things I want you to keep in mind. So which is section 10 of Indian Contract Act. I already showed you the bare act. One has to possess that, and one has to read even 100 times is less for that, because making a contract or writing a contract, interpreting a contract, understanding a contract is very lucrative. I'm telling you, people are charging from anywhere 2,000 to 5 lakhs for a contract. So contract writing is very important and very lucrative, and not only for money. And those people who are strong at contract would be looked high in the legal field. So section 10. Section 10, when there is a contract, means these five should be there. Otherwise, it is invalid. There should be money flow from buyer to seller. There should be competent to contract. Both have to be above 18 years. If one is below 18 years, they have to be represented by a senior, I mean a major. Next, there should be free consent. He has to agree at free consent, not at a dominant position, not at drug, not at incapacitated, not at something else. No, he has to have a free consent, not at a criminal intimidation or by force. Next is there should be legal object. What is legal object? Legal object means which is legally can be given and taken. Suppose I gave 5 lakhs to you for giving me IAS post. Is it a legal object? Answer is no. It is not a legal object. I gave 10 lakh rupees to get somebody's hand. Is it a legal object? No, it is not a legal object. I gave 10 lakhs for buying a property. Yes, it is a legal object. Next, as per law, not void by any law. So as per law, not valid by any law, not void by any law. Suppose sending rice like a month back to US is as per law. Now sending rice to US today, the small rice to US is void, because Indian government stopped, banned the small rice from India, keeping or anticipating the demand of rice by the at the anticipation of the heavy rains. So this is one thing. So this block, one has to keep this in mind. These five should be there. There should be a consideration. They both parties should be above 18 years. There should be free consent. There should be legal object. There it is the as per law, not void by any law. Next block. What is next block? PPTS. So whenever you write, the party name should be spelled out in affidavit format. What is the party name? Name, son of, aged, occupation, resident of. This is nothing but in the affidavit format. You have to have, and that particular Mr. A should be uniquely identified by son of, age, occupation, and resident of. Next, so party names, place, date, and time, system where contract is made, state, country to find which governs the contractual law. Some people write contracts in America also. Here, as I told, there is same thing, two things. One is seat and venue. Seat decides the law. Suppose you can sit in America, write a contract under Indian Contract Act 1872 or which governs Arbitration Act also. So you have to decide which governs means the jurisdiction part. And the third block is this. So actually we spoke lot about these things. Representation made by each party, warranties made by each party, the covenants, condition precedents, and remedial measures. These should be part of a contract. It is not only when you are making it, always think twice. So you will be sometimes making the contract. On other hand, sometimes you will be reviewing the contract. So in both sides, make sure these are there. If you are making it, make sure these are there. If you are other side reviewing it, make sure these are not left out. So with this, I will move on to the topic one, contract breach and execution. As per Chaos theory, you know that, right? So the chances of meeting requirement and the chances of not meeting the requirement. Suppose if I say I will come at 6:30, the chances of coming at 6:30 and the chances of not coming at 6:30. As per Chaos theory, the chances of not coming at 6:30 is more. So always if there is a contract, so we know that the remedial measures, the sunset clauses, we have to make sure if that contract is not met, what is that both parties agreed to do, so that that will be on the paper and it will not be left out to interpretations or the disputes or like quarrels in the court. So it should be spelled out in the contract. So contract breach, an act of breaking in terms of out. So now we will understand first what is a contract. So, what is a contract? So, for a simple example of a contract, when you buy a product in a store, so you say that I'll give 500 rupees, you give this particular product, and in this 500 itself, it has to be delivered at my address within 3 days. Is a contract. When you got a job, for example, a person borrows 10,000 rupees for a car from a bank and fails to make one of his monthly payments. This means that the loan has become default. It is a contract. So if it is a default, what is that? So one default is okay, or two defaults are okay, or three defaults are okay, or even on one default, the 9% interest will shoot out to 13% interest. Is a contract. Is a contract. So now once contract is broke or defaulted or breach, what to do? So we have to go with different damages. So for example, we have uh, four kinds of damages. I will go ahead. One is punitive and vindictive. We will go through one by one. And the next one is, give me a second. So one is punitive and vindictive damages. The second one is compensation. The third one is specific performance, and the last one is restitution. The last one is restitution, and we will read one by one. So these are the four options the aggrieved party from a contract of being breach. So these are the four things. One is punitive or vindictive damages. And by name itself, you all know that punitive means the punishment. So what is this? For example, the court will take the punitive damages just to make sure, deter the public not to do such things. For example, the the RTC is making 5 minutes late, 10 minutes late, usually by default. And the people who plan for interviews, those things, they are getting delayed and they have inconveniences. And that kind of things, not to repeat them, court will take a punitive or vindictive damages or exemplary damages so that people will not do it, precluding from doing it. Next, what is next one is compensation. So compensation is nothing but, in normal circumstances, damages are usually as compensations for pecuniary losses incurred due to the breach of contract. For example, I will tell you, there is a case law. Um, in a laundry shop, the laundry machine has been repaired and he has given it to the repairing. He told he will deliver it in 5 days, but he delivered it in after 15 days. So because of not being delivered, the laundry man, an average of 1,000 rupees per day, lost the business. Lost the business. So 10 days, 10,000, plus also reputation of not being on so punctual. He was very punctual, so his reputation is gone. So, so the 10,000, 10 days into 1,000, 10,000 plus reputation, say 10,000. 20,000 would be given. Here only the pecuniary. There is no actually real loss, but the compensation would be given. Next is specific performance. Yesterday we discussed specific performance. As a remedy, specific performance used when award monetary is not adequate. So specific, the word itself is specific, it is not general. The general means the money would be given. If it is specific, that has to be done. As I told, like you engaged a person who can sing well in our bar from 6 p.m. to 10 p.m. or 8 p.m. to 10 p.m. and they haven't come and they were singing in opposite bar. So you can go ahead and file a specific performance injunction suit on them for two things: stop singing in that bar, and second thing, come and sing in my bar. So this is a specific performance, specific, only that singer can sing. So no other people. Only exception is when their throat is gone or they are died. So these are the two exceptions. When their throat is gone, you cannot go ahead and do a specific performance. And when they are died also, you cannot go ahead and ask for a specific performance. Those are the two exceptions. And the goal of restitution, next, last one, we studied about punitive, we studied about compensation, we studied about specific performance, we studied about restoration. Restoration, I think by name itself is a restitution, keeping you back where were you before the breach of the contract. The idea is to put injured party back on the position he was before the breach of contract happened. This is exactly, they will keep you before. Suppose um, there was a building happening and they were digging big holes, and because of that your the portico or your wall or whatever fencing wall got damaged, and they will make it as it is, they will construct it back and give it back. So they will put you before as it is. And if you cannot live there, they will get you a new accommodation till it get repaired and place you back in the old house. That is called restitution. These are the four things, and I'll pause to all of you to go ahead and read once again. You all understood those four of them. They are very important, and when you're looking or when you're hearing your client, you have to decide among these four. But let me complete. When it comes to the court, you will not be asking like this. Always you'll go ahead and file specific performance, and anyhow you will have the blanket relief. What is the blanket relief? Uh, what is the blanket relief is any other relief or reliefs as this court deem fit in the circumstances of the case, in the facts and circumstances of the case. And I want to tell you, in the prayer, you should have two prayers. One is the specific prayer and general prayer. The specific prayer is nothing but you are exactly asking. He has taken 7 lakhs from me and he gave me the promissory note and at a interest of 1.5 rupee, which is 18%. Now the 7 lakhs had the interest of 2.8 lakhs. 7 lakhs plus 2.8 is 9.8 lakhs. So direct him to pay 9.8 lakhs from the date of the promissory note, not from the date of initiation of the suit, from the date of the promissory note, and any other relief or reliefs as deemed fit by this honorable court in the facts and circumstances of the case. So you are putting specific payer, you are putting general payer, and you are leaving it there. So if at all something court feels more, there is a standard rule in jurisprudence that court should not give you more than you asked. More than you asked. The other person will ask, he hasn't asked that, why are you giving? That is the reason you put that general prayer. So whenever judge feels so inclined to you, so he gives, suppose your like your party is a senior citizen or aged person, and this case has dragged so much, he lost a lot of stuff. So he can give you more than you asked, and he put that more than what you asked in the general bucket. General bucket. So you all read this four. You all good on that four consequences of breach of contract? Perfect. So now we are moving on to the. I think we are done here. We are moving on to the proformas now. See the rental agreement or rent agreement. You all know what is rental agreement or rent agreement. Most of the times we go ahead and have a contract with the owner of the building or apartment or whatever it is. We make rental agreement. And what would be the inputs? Always, as I told, I think I want to show you. I think I want to show you. So this is what I was always telling. This is the input, this is the process, this is the output. So hope you all can see this. You all can see this? Okay. So, no, sir. Okay. Not clearly. Now, yes. So, yes, clear. The center is a rental deed, whatever the big circle. I encircled rental deed, okay. And you see a lot of inputs going into that circle, and only one output is coming out of that circle. Is that clear? Yes? Okay. So now without that, I want to tell you. So now you see so many things are going on, but the right side is only one coming out. What is that? A deed. So you make whatever been asked, you make it a circle, encircle it, and see what are all going through that. It can be maybe 100 also. So make sure you give a legal object to that, legal language to that, and whether it is not void by anything, and it should be always valid. And then the output should be the rental deed. For example, recently Supreme Court told that only 1 month advance. In Bangalore, they ask for 10 months advance. It is not correct. And in Hyderabad, people are asking 3 months advance. but like Rent Control Act is not being properly enforced. The one of the most root cause in India for a lot of price shoots are the rents. Rents are too high. So because of that, lot of problems, and the end victim or aggrieved party is the customer finally. So let's go into the rental agreement. Let me open that. Rental agreement. Yes, no?
Yes, sir, it is visible.
Perfect. So now I will, the first party, so we will call as a first party, the owner, one part. You can call one part and second part, or first party or second party. I leave it. I think more possibly call that as first party and second party to make more sense. So as I told, you have to put the each party as in affidavit format. I so and so, son of so and so, aged so and so, occupation so and so, and resident of so and so. This is affidavit format. Once that is done, owner and tenant, and you will have the where is the house. And as I told always, what you have to do, the representations of the first party, the representations of the second party, yes. And what is the other one? The covenants. And what is the other one? The guarantors. And what is the last one? What is the last one? The promises. Okay. And sorry, last one is the remedial measures. So now let's read this one. You all can say this. I'll make it bigger. So you say that rent of the schedule is 8,000, and which shall be paid by the tenant to the owner on or fifth. You can put very small things also, on or before fifth day of every month. Next, that the tenant has paid advance of 8,000 here 1 month only. So which is refundable by owner at the time of vacating the termite. That the owner enhances 5% as standard on every 2 years to the tenant. So he has put that one. So next, the tenant period is 2 years. A rental agreement comes into force with 1st August 2015 to 30th August 2019. Yes, sir, it is. So it is how many years? 5 years. Next, and the rental period is further extendable, which the mutual consent of the both. Next, the tenant shall use the said portion for residential purpose only and not sublet the, there is a sublet condition. We discussed, you remember, sublease. So sublet condition. Next, the tenant shall pay the water charges and electricity charges in time and hand over the receipts to the owner. However, the property tax shall be payable by the owner. Done. Next, the tenant shall keep the premise in good habitable conditions and shall not damage or alter the construction and shall return the said premise in the same condition as they have taken the said premise on rent. If any damages caused by the tenant shall be borne by him only. Next, the that either party can cancel within 60 days notice. Next, the owner have the right to visit the said property reasonable time with permission of the, so he can inspect the property. Next, the rental agreement on its expiry can be renewed by mutual agreement. Okay. So you all have read it. I think the one, even as I told, the minute things can be captured here. And one thing I think prima facie, if you all see here, I think you don't need to tell right away. You can tell that something is missing here. Something is missing here. What is that? Either I purposely missed out. What is this? You tell me. Anyhow, with like I'll take a 30 minutes pass and I'll tell you. See, you are telling all these things. What is missing here? Or I will go through this and let me post this on the screen. Where is this? And now check all these things. You can see my PPT.
Yes, sir, it is visible.
Perfect, perfect. You just try to, this is your mirror, like these are your goggles. First block, second block, third block. You have to see any contract with these goggles. Now, keep this in mind, or you can take a screenshot of it and then keep it on other side. Now I am flipping back to the contract again. So what is missing is, I can tell you. What is missing is, perfect. One is place is missing. You can take time. And the second is, they are telling you have to give rent on or before 5th. You can mention how, either through cash or through online. If it is online, to which account? That is one thing. And if it is not given, if rent is not given, what to do is not mentioned here. What to do is not mentioned here. And how the tenant shall keep the premise in good conditions, habitable conditions, and shall not damage. So what about normal wear and tear? And what about whitewash? Whether it whitewash was did and given, or whitewash was not done and given. And if white was what done, while leaving, the tenant either do whitewash and give it, or arrange a person to do whitewash and give it, or let owner do whitewash and pay for it. Pay for it. That is also not mentioned here. So you can go to minute details. Why I am asking you to go to minute details is, when it is a silent, contract is silent, or contract is vague, it is the lawyer comes into picture and they interpret into their own favorable. And also here in this, it is not mentioned who is going to born for the drafting of rental deed and reducing that into a rental bond. Who is born that 2000 or 3000? Both parties are keeping that, or only one party is keeping that? That also not mentioned here. Okay, these are the three things, couple of things. When you make a contract, I am telling you, you blindly keep, if the rent is not paid on the scheduled time. Yes, perfect. So I want to tell you, this is your whatever say Bhagavad Gita or Quran or Bible. Keep this in mind, and always this is like your goggles. Keep this and view the contract. If these are all are there, perfect. And I'm telling you, there is nothing called silly. If somebody smiled at you, laughed at you for silly things, if they are elders, you can just keep quiet. If they are your colleagues, you can also smile back. If they are your juniors, you can also laugh back. So there is nothing called silly in making a contract. The minute detail will prevent you. Prevent you means protect your client. Okay. So having said that, I will move on to the next one, which is partnership deed. So partnership deed, we will go on. Let me know if you all can see my screen.
Yes,
Partnership.
sir.
Yes. Perfect. So now, so we are making a partnership deed, and before going into that thing, so why we need a deed for partnership? We all discussed. So we had a proprietorship, like one man army. He can do everything. He can bring land. He can bring machinery. He can bring money. He can bring labor. He can bring intellectual property, ideas, all that. That was the proprietorship, and that was very uncommon to have all the qualities for a person. So pool of people pooled together to make a firm. So that is when partnership comes into picture. One man, he brings idea, he brings money, he brings machinery, he brings land. So all these people form a partner. So then they will call as a first partner, second partner, third partner. And we also discussed when each has to sign means whoever have obligations to sign it. Who don't have obligation, if he doesn't sign it, the contract is still valid. But who have obligation, if he has not signed it, that is becomes useless document. So now, as I told, we discussed, so we will put like about the partnership, all that place. Now, immediately, this is important. Now, this deed is partnership witness with as under. So we discuss what is the name, how the name, where is the place, and how much is the total money, who is bringing it, and how the profits will be. Here it is 50-50%, how it would be shared among people, between you all, how it would be shared it, and who is active partner, who is sleeping partner. You procure all each and every document into that. And also you can put, if one person is leaving out, right of redemption. Right of redemption means, I want to bring a new concept here. What is right of preemption, not redemption? Right of prevention means, right of preemption means, how can I tell? Okay, so you were in a rental house, uh, in a rental house, the owner, and you are there in the house for say 5 years, for 5 years, and when owner is selling the house, the right of preemption comes into picture. What is the right of preemption means? You are the first one to entitled to buy the house. Right of preemption. So owner to tell you that I am planning to sell. If you have anything, please go ahead. This is right of preemption. Yeah, right of preference. But right of preference, I'll tell you. Right of preference, it comes in the elections. Right of doctrine of election, whom to select. So right of preemption is you would be selected first. This is called right of preemption. So here, why we got right of preemption? Yeah, we got deed opened. So here also, when one partner is leaving, you cannot go ahead and sell it to somebody else and leave, because he is going to bring some new psychology, some new modus of operandi, or he have different mindset altogether. So instead of that, whenever somebody is leaving, you can put right of preemption clause also, that first you have to let us know, so that if at all we have appetite to absolve, we will absolve your partner, your partnership share, so that we ourselves buy it and you let it go. So this is a smooth thing, and this would be shared with you. And these are all self-explanatory. We will pick anything. Okay, we pick the ninth one and read. Lend any of the monies or deliver upon credit any of the partnership business activities. The partner should not give any premise or request for the payment of money on the account of firm. The partner. So you should not give, you should not take or give the monies. And you can say that if at all somebody is taking or giving money, how the money flow should be there, who has to sign it, and with how many days you all will sit and discuss on that. You can put that also. So you procure each and everything. There is nothing silly. You can go ahead. So let's read again, as you say that. The partnership shall have the name of this one. The place would be Rangareddy district, so and so. The partner shall be deemed to have come into existence from so and so. Next, the nature of partnership business shall be at the stationery, so and so. Next, the partnership business shall be at the stationery fancy Bangalore store, and such business place a rent of 15,000. The capital of that is 8 lakhs, and it is borne by two people 50-50%. The profit and losses of partnership shall be shared equally by both the partners in proportion in the capital, and previous accounts till date should drawn as early as possible, and should not take assent by, and should take, sorry, should take assent by the parties. And okay, pause here. And should take assent by two parties, and thereafter the account shall be shown every month and draw profit. Pause. So there is a flaw here, and just 10 minutes pause. What is the flaw here? Should take assent by both parties, and thereafter account shall be drawn every month and draw the profit and loss without fail. So there is a flaw there, or instead of flaw, there can be better there to avoid interpretation. What is that? No mandatory compliance. Should is a mandatory, right? Should is a mandatory. What is the other one? Probable guess. All the contracts should be mostly written. So here, now this would be subject to what? This would be subject to what? Should take assent. So here, instead of saying should take assent and it should be in written form. It should be in written form. You got it now? So now you should have that piece of email or piece of letter that it is written. So once it is written, he says that now I WhatsApped him or I called him, he said okay. He said he haven't called him, he have not told him. Over. Or I told his mother, I told his brother. Or I thought like he will not say no for it. So now you understand? Now interpretation. Now it is a dispute. So if we say that there should be assent and it should be in which form? Written form. So once it says written form, you should have two assents and they should be tagged in the file. So perfect. So there is no confusion. So once that is done, we are done with partnership deed. You all okay? Okay? I mean, this would be shared with you. No need to worry. Next, going back again to our PPT. Next one is you all see my PPT. So lockout agreement. Okay. So here, I mean, this term is usually lockout agreement. People can understand in two ways, but for now we will understand fixing a price. Fixing a price. So the lockout you would listen in Industrial Dispute Act. You know the industry goes on lockout. So that is a different thing. And here fixing a price. So we will limit to that, and I will open that lockout agreement for you, and let's see. You all can see?
Yes, sir.
Perfect. So, okay. So as I told, lockout is nothing but you have a price and you want to lock it. So agreement made at so and so day between Mr. A, hereinafter referred as the seller and as first party, and Mr. B, hereinafter referred to as the buyer and second party, in consideration of a token of so and so paid by so and so buyer, the seller this day, the receipt of the whole selling having acknowledged, the seller agrees that during the period of so and so days, months from the date of called lockout period, the seller will not conduct negotiations with any third party for the sale of property of the seller, being the piece of land at measuring so and so meters having so and so so and so so and so, will not send any third party a draft contract sale of title deeds relating to it. Next, the seller agrees forthwith to instruct his advocate solicitor to send the contract and other relevant papers to the advocate solicitor acting for the buyer to deal promptly with any amendments to the contract and any inquiries raised by on behalf of the buyer. The buyer agrees forthwith to take all the necessary steps to proceed with the proposed purchase of the said property, including the approval, the contract and title of the property, arising inquiries, so mortgage, all that. Okay. Next, this agreement will lapse if the buyer informs the seller that the buyer no longer wishes to proceed with the purchase of the said property upon the expire of the said lockout period, whichever event happens earlier. Next, this agreement is independent of a contract for sale and does not bind the parties to sell or buy the property signed by the seller. And this lockout now is kind of replaced by either agreement to sell or MOU. Agreement to sell or MOU. These conditions you have to come back within 45 days, all that. So this lockout is nothing but can be used by a more corroborative, and also you can have this lockout for fixing a price also, fixing the price also. You made a contract now, and in 6 months you would not increase the prices, so you stick to the prices what is being locked out. So this is what, and lockout is more likely not been seen now. It is replaced with the MOU or agreement to sell. So we will have all those conditions plugged in there. So once this is done, we will go back to our window. Next one is partnership. Did we did? Next software agreement. Next is case laws. So you all see my screen. Software agreement. Okay. So software. Good for agreement. 1 second. Okay, you all see my screen. This is a sample thing. I'll tell you. You all see my screen?
Yes, sir.
Perfect. So now the software agreement. You can have the software agreement for many things. One is for the operations, other is for the just for antivirus yearly updates, and other for the supporting your LAN, WAN, computers, cleaning up, maintaining all that stuff. You can give this to somebody, and like a lot of portals are there, right? Like income tax of India, Dharani portal, you know, the High Court portals, National Consumer Forum portals, and all these portals. So is given to some people. Is given, even TCS is some of the vendor for giving software to India. So, so with this, we will mention about as I told, always keep this in mind. So you have to have the details of the first party or parties, details of the second party or parties, the relation between party 1 and party 2 or parties 1 and parties 2. So you have to give those three details, and after giving that you have to as witnessed with. So we are going to as witnessed with, and we will see what is that. Now that the consideration of the payment rules is made on the execution of this agreement on the receipt and the premises and the payments of the services hereinafter hereinafter. Next, the programmer shall deliver to the consultants of the said of the consultant the said software not later than. So if the programmer fails to do so, the consultants may serve a notice to the programmer to deliver the completed software to the consultants within a stated period, not less than fortnight. Fortnight means 2 weeks. So, and if the programmer fails to comply with the said notice, the consultants may terminate this agreement, whereupon the programmer shall refund to the consultants all the amounts paid to him by the consultants and return all the books of reference supplied by them to the programmer. The consultant shall also be entitled to recover the part of software and notes prepared by the programmer, provided, however, that if the software be completed more than half of the total work, the programmer shall be entitled to half of the total sum of the payable to the programmer under this agreement for parting with the said software. the consultants will pay sum of dash dash when the approximately half of the said software is ready, and further rupees shall be payable at the delivery of the said software. The consultants will provide the programmer personal computer, books, compendiums. Compendium means bundle of book in one book, and other material required by him for the preparation of the said software. If the consultants are not able to supply any book or any other material required to the programmer for the preparation of the said software within a period of 3 days from the date of receipt of this request from the programmer may purchase the said book and material, and consultants will reimburse the programmer the cost of the material. So I think a question here. Question here. So just a good thing here. So here, if within period of 3 days, within period of 3 days, if the particular condition is not being met, and what is that, remedy is also given. Who is remedy? The vendee, the person who is providing software, will buy the books from the market and get it reimbursed from the vendor. So this is called sunset clause. Sunset clause means there is a contract, there is a promise, and if that is broken, what to do? So perfect sunset clause, remedial measure. Next, you all noticed this one? You all noticed? Perfect. So here it is a perfect sunset clause. So the remedial measure is also mentioned here. Next, the programmer assures that consultants that the said software will not infringe or violate the copyright of any other person. The programmer here indemnify and keep the programmer, vendee, who is giving software. The consultants indemnified against the claims, demands, and damages, loss, cost which consultants may sustain by the reason of any of the said software infringes the copyright. So the whole thing is what is saying that the person who is providing software should not copy from somebody else. If he copy from somebody else, who will be hit by that? The vendor, the whoever taking the software, you will get in, you will hit by that. So that is the reason they are putting indemnity clause. What is indemnity clause? We already studied. Indemnity clause is nothing but to make fill the losses, to make good fill the losses. So you encountered anything, who is the responsible? The programmer is responsible. Next, on payment of all the on sums of payable programmer under the agreement, the copyright of the said software will vest in the consultants. So the programmer should not that I made the program, I will have copyright. No, you are the programmer undoubtedly. We made you, we make you payment, and now we are the owners of the program and we have all copyrights. So it is witnessed with two people. So scanned and two people are signed it. So that is, I mean, I can leave a pause. You can, if you have any questions, you can write down. So we will go through that. And we have one more to cover, that is the employment agreement. So we will go ahead and, sir, please explain sunset clause. Okay. 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 So you all see my screen? Red color?
No, sir.
No? So, okay, there is a question. Let me answer that. Employment and, okay. So what is sunset clause here? So you all see my red here?
Yes, sir.
Perfect. So let me read this aloud. Okay. The consultants will provide to programmer personal computer, books and compendiums and other material required by him for the preparation of the said software. If the consultants are not able to supply any book or any other material required by the programmer for the preparation of the said software within a period of 3 days from the date of so and so, so and so, so and so, what we are doing is we are buying it and get it reimbursed from the consultants. Somebody asked what is a sunset clause here. So here they are putting a condition. They should provide it. If they do not provide it within 3 days, they'll go ahead and buy it and get it reimbursed. So it is not, the loop is not completed here. Is there anything open like this, or it is like this? So it is like this. It is completed. So you have a condition, and if there is a possible default, and you have a remedy. So you have a condition, possible, default, and you have a remedy. So is it like this? Is it not? The whoever, the gentleman or gentlewoman, whoever asked. So the condition is like this now. It is a circle. So it is complete. Is it not? So this is perfect sunset clause. Perfect sunset clause. And a question to you, one more. And in this, one thing is missed. One thing is missed. So I will read for you one thing, and you have to tell me what is missed. Okay. Here, from the programmers, from the contents consultant side, they said if the programmer fails to do, the programmer shall deliver the consensus set software not later than so and so. If the programmer fails to do so, the consensus may serve a notice to the programmer completed software within a stimulated period not less than fortnight. Okay. They are putting from their condition, fine. If they are not giving, they said that we will not give any money. If it is more than 50%, we will give. But having this, what is the link between these two red ones? Kindly think. From the consultant side, they are putting a condition that you have to deliver so and so days. If you don't deliver, we will give a notice and we will cut the payment, all that. Okay, fine. What is the link? Can you, if you are working, say, for the programmer side, not on the consultant side. If you are working from a programmer side, you can link these two. How you can link these two? I'm giving a 10 seconds pause or 20 seconds pause. Please think. If you are working from the programmer side, think these two rates and how you are going to protect the programmer. Think. Even if you think silly or wrong, also you can type it in. Programmer can say that items are not delivered. Okay. Or not delivered on time. Okay. Yeah, that is also one thing. Okay, so you can link these two, saying that if you do not deliver the books within 3 days, I will go ahead and buy it and then take it. And then that 3 days and buying time, say 4 days or 5 days or whatever it is, that should be extended to the delivery time. Is it not? You got it? You can link those two. So 3 days plus you procure the books, right? That can be 1 day or 2 days, right? It is not only the money, you have to append the time also. You guys with me? Okay. So here, how can you link these two is, he is saying he is putting a condition on the programmer that you have to deliver it. And here, if he fails to give the books and all the compendiums within 3 days, the programmer will go ahead and buy in the open market and get it reimbursed. So it says that it will get it reimbursed. That is only there. But what about the time? 3 days plus procuring time. That is not been answered here. So you can link that time, that 5 days, you can relax it by 5 days here. This clause comes into picture. You got it? So this is how you have to think and protect whomever comes to you. Programmer comes to you, protect him. Consultant comes to you, protect him. Owner comes to you, protect him. The tenant comes to you, protect him. The service provider comes to you, protect him. Service taker comes to you, protect him. The vendor lease comes to you, protect him. Vendee comes to you, protect him. So much to thinking. Okay. So this is done. And the last one, we'll go ahead and take it up. The last one is the employment agreement. And again, I want to show you this one. This is, I'm telling you, this is one wonderful piece of depiction. You can take a screenshot or write it on your notepad. Again, I'm telling you, what is the center? The employment deed. The left side are the conditions. What is the right side? Only one thing, that is employment deed. Having said that, I am going back to the employment deed. So in employment deed, what are all the there? So again, going back, what are your goggles? So you all see my screen?
Yes, sir, it is visible.
Okay, perfect. So this is your goggle, the spectacles. So the first one, Section 10 of Indian Contract Act 1872, which has 5 points. Next is PPTS block. Next is BBC block. Make sure these are all plugged in. Some might be not applicable sometime, but make sure these are all there. Now, with these goggles, we are going to review the employment deed. This agreement is made on the day of so and so. So straight away, one is missing. What is that? Place. One is place is missing. So whatever next, a company incorporated and all these things registered and so and so. So this is the company, and this is the employee. And if you have any definition clauses, you have to put definition clauses: associate company, calendar year, probation period, votes of importing, any reference to statutory provisions, any reference to company shall, if applicable, include his authorized. Next, reference to agreement to any clause, subclause, schedule, paragraph. Next, terms of employment. The employment of the employee shall be deemed to have been commenced on the date of actual reporting in the premise of the company pursuant to the execution of this agreement. Next, the employee shall be under the period of probation. On commencement of his employment, period of probation shall be 3 months. The company shall have the option to extend the period of probation by other period of 3 months without assigning any reason. So what is missing here? So this will not stand in the court of law. If everybody is seeing, question to all of you, this will not stand. Yeah, everything will be shared right after this. It would be shared with you. Legal expatriate will share with you. Can you see my screen?
Yes, sir.
Okay. Okay. So this will not be shared. This will not be stand in the court of law. The company shall have option to extend period of probation by any further period of 3 months without assigning any reason to the employee. So this particular thing will not stand in the court of law. Why it will not stand in the court of law? Because this is kind of a dictatorship. When it is a dictatorship
Sir,
or
sorry to interrupt, sir, but your screen is showing inputs to any contract agreement slide.
oh, I'm sorry. That's the reason. Thank you. Okay, can you see my rental agreement now? Sorry, employment agreement.
Yes, sir.
Okay, so this particular clause, period of probation shall be 3 months. The company shall have option to extend the period of probation for further period of 3 months without assigning any clause. This particular clause will not stand in the court of law, and I will tell you why. Because from Apex Court, Supreme Court of India have a clear directions. Any decree or any order should be reasoned order. They are using the word called reasoned. What is reasoned means, when that order is given, they have to mention why that order is given. A unreasoned order, a unspoken order is void or can be set aside. In the same way, why? Because one should not be a dictator when he's saying that this is the reason I am not allowing you, or this is the reason I am extending you, this is the reason I am giving promotion to you, this is the reason I am not giving promotion to you. When such a reason is not there, the the Article 311 of Indian Constitution 1949, Article 311 is principles of natural justice. Principles of natural justice The very first one is audi alteram partem. And what is that means? Nobody should be punished with being unheard. So first thing is we have to listen to him, and second thing is there should be fair play, fair justice. So the opportunity of being heard, the opportunity of being representation, the opportunity of being knowing why no one should left, yes, no one should left unheard. So adi alteram partam. So these are the three things. So the very principles of natural justice has been condemned here. That is the reason this without assigning any reason is been taken out. So next, the duties. So you can mention all the duties. Next, hours of the employment 9 a.m. to 6:30 p.m. during week hours, all that. Next, place of employment, you can put that. Next, remuneration, you can put that. Next, leaves, you can put that. Next, absence due to sickness by injury, you can put that. Next, disciplinary leave, discretionary leave, you can put that. Next, termination of contract, you can put that. Termination of the contract means we already discussed. Next, change of job. Let's take one. Change of job, we'll see. The employee shall be required to accept the variation in the content of their job or transfer to a similar job subject to any such variation or of change in job content or transfer being consistent with the type of work normally taken by the employee on terms no less favorable than currently apply to the employee. Next, supplementary earned income. Next, confidentiality clause, non-disclosure agreement. So you have to read this also. The employee shall, during the course of this employment under this agreement, keep all the information with respect to the business and financing of the company and its dealing transactions and affairs, and likewise in relation to its associated companies. All of information is or may be confidential. The employee shall not, during or after the period of his employment under this agreement, divulge to any person whatever or otherwise make use of a trade secret or any other confidential information concerning the business or finances of the company or any such information concerning the associated companies. All notes and memoranda of any trade secret or confidential information concerning the business of the company and associated companies. Associated company means sister companies, or any of its suppliers, agents, distributors, customers, which shall be acquired, received, or made by the employee during the course of employment shall be the property of the company and shall be surrendered by the employee to the company on the termination of the. And I will tell you this non-competitive agreement also. Non-competitive agreement means suppose I work for say Verizon. So when I was there in US, when I was working for Verizon or US Bank or Bank of America, so on the legal side, and when I'm working to Bank of America through say Infosys, so there is a clause in the Infosys saying that so and so Thulasiram, and so you should not join Bank of America. So I'll come. NDA is I'll come there. Yeah, NDA is same. NDA is same. So I should not join Bank of America. So how 6 months? So when I resign, say Infosys, I should not join Bank of America 6 months. Some people say 1 month. This is the non-competent clause. Or some people will be having say that I'm working for say Seattle Boeing. So you know that Boeing makes aircrafts, big aircrafts. Now I am working for a Boeing aircraft, and I will sign with the Boeing saying that I will not join NFL. I mean other aircraft business for 3 years. For 3 years. So, or let's take very valid thing, the like Dadu sweets. When I'm working, suppose I am say master chef in Dadu sweets. When I'm making sweets, I will have a non-competent class. I should not join or I should not start my own business for a period of sweet business, not any business, sweet business for a period of 3 years, 2 years. This is a reasonable class because I work there and I learned everything, and then Daudu Sweets will invest on me. I learned everything. I'll make it instead of Daudus, I put papas or mommies or something like that, and I would become a very competent. I will have very competent edge over Daudu Sweets. So the reasonable, not lifetime, very reasonable time. very reasonable time, because restriction on employment is violation of Article 21 of Indian Constitution. Next, so somebody is asking, yes, NDA agreement is this only. Any NDA agreement, and NDA agreement, how NDA agreement goes like this. Suppose Infosys working with the Bank of America. So Infosys gives NDA agreement to Bank of America. This is one thing. And the second thing is Infosys takes NDA agreements from everybody and keep it with them. But the especially the US companies, like American companies, what they are doing is they are taking NDA agreements and background check and drug test of the employees. All the records they are keeping with them. They are keeping with Bank of America itself. Okay, this is how it is going, because the business is very important, and the contacts you have, like how the trade secret, there would be a lot of things, and all these things are very important, and whenever they go, and it is a loss to the company. So that is the reason they do background check, and especially American companies, they are doing drug test as well. So with this inventions and non-solicitation, non-competition agreement. See, we'll read this agreement. The employee covenants. The employee covenants means conditions with the company that he will not, for the period of 2 years after ceasing to be employed under the agreement, either on his own account or any for other person, firm or company solicit or entire away or endeavor to solicit the entire away from the company or any other subsidiaries, any other respective employees, the employee further covenants with the company that he will not after ceasing to be employed. Here they are telling not only that you go, you should not call your friends also. You should not call your friends also and make them join your company. This also he is taking. You should not start first thing. You should, if you what all you start also, you join, and you should not call also. So that is also there. So next, arbitration clause. Arbitration clause. Arbitration clause is nothing but we will not go to the court, and we will first resort to arbitration. We will sit and talk in presence of an arbitrator. Next, jurisdiction. This agreement is placed here. So this agreement is governed by and construed in accordance with laws of Indian Evidence Act 1872. So you can put here, or you can put Singapore Arbitration Act, or you can put London Arbitration Act. So you can put all that. So all these things. So this plays all that. With this, again, going back to our schedule. So let's recap what we have done. So employment agreement is completed, rental agreement is completed, partnership, lockout, partnership, software, illustrative. You might be seeing this twice, don't worry. So here we partnership agreement and partnership deed. And partnership agreement would be input to partnership deed. That's all. So, and with this, we can go ahead, and I will hand over to legal expatriate for questions.
Thank you so much, sir. This session was very enlightening for all of us. And I request all the participants to kindly unmute themselves and ask your questions directly to the speaker.
Sir, please explain the soliciting clause again.
Soliciting means, right? Like you are going and asking their employees to join, or asking their vendors to join, or asking their loaners who give money or business to them to convert to your potential client. You should not go there and do that in any manner, because you start same business and you have the clients. If you start same business, you have the same, you are expecting same clients, right? You worked in their sweet shop, now you started, so your audience would be, your clients would be their clients, so you want to convert them to your clients, so you should not approach them in any manner. No solicitation.
Hi, sir. Sir,
Before going there, the person,
non-com isn't. Yes.
before going there, the person who asked, is he okay with the answer or any extensions?
Sir, I just to know that in the contract act, it is that every person have the right to trade and business. So isn't the soliciting clause against this thing?
Yes, yes, yes. It is against, but reasonable restrictions are allowed. So in 19, when if you look at, if you have a constitution, the freedom of speech and expression. So the freedom of expression and speech, from there only, you can select any place in India or you can select any work in India, from Kashmir to Kanyakumari. There should not be any restriction. But at the same time, 19.2, A2, F, you have reasonable restrictions. You have a restriction on everything, you have a restriction. For example, so people can speak anything and everything, but at the same time, the reasonable restriction is you should not defame others. You should not defame others. And you should not talk very bad about judges. So it is a restriction. It is a restriction. And at the same time, here you can select any job, but you can do any business. What is reasonable restriction is this: you are working for a company and they invested on you all that, and in 2 years you should not start the same business, or you should not join the competitor. That is a reasonable restriction, not a lifetime restriction. You understand
Thank you,
that?
sir. Okay.
It is
Yes, sir. Thanks.
reasonable. A clause of reasonable restrictions. You can go ahead and resort to Article 19. You will understand reasonable restrictions.
Thank you, sir.
Perfect. Next. Yeah, the gentlewoman.
Yes, sir. Sir, actually, it is related to this particular question also. Regarding non-compete clause, as you have talked about restrictions, but I have actually gained the experience in the particular field. So after leaving the company, obviously, I will, join another company having the same, same field. So isn't this the
What is what?
proper
Yeah,
restriction?
no, no. What is same field? You should have a niche. I mean, see, to attract non-competency, there should be three things. One is they should have invested in you first. So I worked in Oracle, and then I will join other Oracle programming. No, that is not a restriction. You should not take that up. You should not take that up. There should be a niche business and a niche skill, and that company have invested in you. That is called. So entire advocacy is not a non-competent class. You're good.
Right, right.
So there should be a niche
Okay.
thing. For example, let's like a Coke. Coke you are working, Coke, or particular cancer malignancy
Okay.
drug you are working, and they have invested too much on you, or you are working in ISRO, or you are working in Pentagon. They invested on you so much money, and you cannot fly off after taking that trainings. Okay, that is called non-competent class. Not like
Yes, sir.
Lock, Oracle, or SAP, or ABAP. No, no such things.
Yes, sir. So, but nowadays, every company is, putting these non-competition clause. Even though I do not have that work, I am basically have a general work. So, but then also they are putting, so they cannot enforce this clause, right?
No, you cannot. They cannot. You have
Okay.
two things:
Okay,
either
sir.
you can apply Human Rights Commission or you can apply Labor Commission.
All right, sir. Thank you so
Done.
much.
It's quite there.
Uh, I think we don't have any further questions, sir. So by respecting your time, I would like to wind up this session.
Somebody have some question. Do you want to read? I mean,
Yeah, sure, sir. I would do that. Thank you.
Sir, I have another question.
please,
It's a general question actually. Sir,
please.
all in all of these agreements, there is some good amount of English used. Then then if I am not so proficient in English, then how can I become good in contract drafting? That's
One second, I was trying to close some screens. Can you repeat that your question?
sir, in all these agreements, a good English language is used, and if I'm not so proficient in English, then how can I become good in contract drafting?
Okay. Uh, so one thing is you can improve English, or you can partner with somebody who has good English. And the third thing I want to tell you, English is very simple language and easy language that I had come across. Only 26 letters when compared to Hindi 300 plus, or Telugu 300 plus, or Tamil 300 plus. And to answer your question, uh, Rome was not built in a day. You cannot get English overnight. Uh, kind of improve every day. That is one thing. Partner with person who has good vocabulary, or partner with a person who is a good penman, so that that would be taken. But I am telling you, English is not a big skill like thinking. Thinking is different. Thinking is actually a skill. And English vocabulary and English spoken, how would I say, like if you have a good English, you can become a good news reader, but you cannot become a good logician or good lawyer or a good draftsman. So logic is the skill, and the language will aid to the logic, but both are important as both will reach the other person. What I would suggest is slowly improve, and also you get partner with a good penman who have good or adequate English. That would be my suggestion. And also just kind of remove that English is just a language like any other language, and it is not above or below Hindi or Telugu or Tamil. It is just equal to that. That's all. Have that opinion so that it will be easy for you. You have a question, and she is unmuted. Okay, you can type it in, or you can unmute yourself.
Hello.
Yes.
Hello. Yes, sir. I had a doubt. Actually, nowadays the companies make you sign an actually it might be similar one, but nowadays the company make you sign an agreement where you can't leave the company for a set period of months. That is 3 months, 6 months, or maybe 1 year. And if you do, they kind of throw shenanigans about giving you recommendations, like recommendation letter and all. But according to what I think, it's not applicable in the court of law, right?
No, reasonable bond is applicable. Suppose you are given niche skills and you are asked for a 1 year period, that is okay. They cannot
No,
ask
sir.
you for 10 years.
You're working in a company at a normal for a normal job, like a BPO, like anything you could say. It's not like a particular skill, but a BPO, which is very common, that type of call
Hmm.
center type. That way I'm telling. So they have this thing that they tell you ki you have to work here for at least 3 months or 6 months that way. And this happened with a friend of mine. So I told him that why don't you leave it, because I don't think so that they can enforce it on you legally, because I don't think they can. So he told me maybe they can't, but the problem is that they throw shenanigans later while giving you the recommendation letter, experience letter, and all.
Okay. Now I'll tell you one thing. I think I understood some of your question.
Yeah.
If it is reasonable, yes, it is valid in the court of law. If it is not reasonable, it is not a reasonable restriction. It will not stand in the court of law. Okay. And
So,
in this context, I want to tell you one more thing.
mhm.
There is a Supreme Court direction that some engineering colleges, private engineering colleges, private medical colleges, and private law colleges, if it is a management quota or if it is a convener quota, they are holding all your originals. And if you get dropped, if you stopped in the first year itself, they are asking you to pay all 4 years fees or all 3 years fees or all 2 years remaining fees in order to give your originals. Okay. And Supreme Court told that you can't hold the originals of a student in any manner. So Supreme Court is coming up. If it is a reasonable, yes. If it is not reasonable, it can be condemned. Whether they are enforcing you, they might give you some problems. I'll tell you, today's crime is tomorrow's law. So somebody have to reach out and voice out in the court or in any forum to get the law out. Okay, there might be teething problems, but you no need to agree for them.
So, sir, in your opinion, this might be unreasonable, right? For the
If it is
company to.
if 3 months is reasonable, yeah, 3 months I would not say unreasonable.
Okay.
3 months is reasonable.
Hello. Hello.
Okay. I think I know we'll hand over to legal expatriate unless you have any more questions.
Thank you so much, sir. So this was a very wonderful session, sir, and we are so honored to have you with us today in this session. So I just conclude the session now. Shall I, sir?
Please.
Okay, thanks so much, sir. Thank you so much, sir, for this wonderful and enlightening session. We are extremely honored to have you with us today. Your achievements and expertise have left us inspired. I am also sure that everybody would have found your insights and expertise valuable and informative. I also thank all the participants for being cooperative during the session and appreciate your participation and engagement. Thank you all for joining. Thank you so much, sir.
Thank you.